Hi, this is estate planning attorney Michael Pevney, and I create estate plans for families. And in this video, I'm going to talk about why it can be a bad idea to leave money outright to children in your estate plan. I had a potential client come to me the other day and they were having a problem. Her father left money in a bank account to her son. So grandpa left about $30,000 in a bank account using a beneficiary designation to his grandson. The kid is 6 years old, and the mom was having trouble becoming the custodian of that account because little kids are not allowed to have control of bank accounts, certainly with that amount of money in it. And the bank was telling her that she had to be appointed guardian of the estate in order to be the custodian of that account and be able to control that money and handle it until he turns 18. And that really kind of sounds crazy because he's the kid's mom. Obviously, she should be the custodian of the account, but that's not how it works because grandpa left grandson as a beneficiary designation the account. Now, otherwise, his estate planning was done pretty well. He had created a revocable living trust. The home went into the trust, and that property was distributed appropriately, but he didn't leave the trust as the beneficiary of that bank account. And because of that, the mom is going to have to go through probate court and take all the time and cost and hassle of that just in order to be appointed a guardian of the estate in order to be the custodian of the account. Because what had happened was 3 years had gone by and the bank is about to send that money to the state as lost property, even though we know the kid's right here, he's the owner of the account, and the mom's right here, and she should be the custodian. The bank needs a court order appointing her guardian of the estate. Now, how can this be avoided? Two ways. First, you leave the bank account to the trust and put directions in that trust that this is to be used for grandson's education. Very simple to do. The trust was already there. Trust you have so much control over, it still doesn't have to go through probate. And a second idea is to open a 529 account. A 529 you can put in investments, they grow tax-free, and the successor owner of the account could be the mom with keeping the grandson the beneficiary of that account. That also avoids probate. So that's just a couple reasons why it's not a good idea to leave a child, a kid under 18, to be the beneficiary of a bank account and, for that matter, life insurance. Because not only is it difficult to become a custodian of that account, it will not avoid probate. There's much less control over it, and the kid gets to do whatever they want with it when they turn 18. So if you have any questions about this or anything else related to estate planning, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. Thank you for your time, and thank you for your attention.